There's been a lot of discussion about 18 U.S.C. 922R and whether or not it's a trap for Americans to admit that they have violated that statute. The answer is unlikely. Let me break it down and tell you why I think the 922R discussion that's been going around the internet is probably not a major threat. And I want to break it down so you guys get what I think is the reality of the situation. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers to help with the social media algorithms. Okay, been a lot of questions out there and a lot of debate, and I don't watch a lot of other gun channels because I don't have the time, but I know this is like a hot topic, so I just want to weigh in on this 18 U.S.C. 922R issue dealing with pistols, and imported rifles and the like, and whether or not someone could commit a crime by attaching a pistol brace to a pistol under sort of these new ATF regulations. So I just want to break it down. The bottom line is this. Okay, I'm going to try to make it so it's very easy to understand, and then you can take the information I provide to you, and you can talk to your own lawyers or your consultants, whoever it is that you're talking to, about figuring out what you're going to do specifically with your situation to the extent that you have pistols with hand braces and how you're going to handle that. But so let me give you some information that I think you can reflect upon with your professional advisors and your lawyers about what you are going to do. Okay. 18 U.S.C. 922R is a crime, but it's a specific type of crime. It's a crime to manufacture or to assemble a gun, a rifle with so many imported parts. But the key word that I just said, without getting into the details, which I don't think you need to know here, is this. The crime of 18 U.S.C. 922R is to assemble. It is not to possess. Again, the crime is the assembling process. The process of assembling a gun that meets the definition of 922R. It is not the mere possession of a gun that would otherwise meet the definition of 922R. So the point is that for the government to put you in prison under 18 U.S.C. 922R, they would have to show that you manufactured, assembled an illegal gun with mens rea, which means intent, at a certain date, at a certain time, and they can prove that. If you merely possess the gun, and that's all they can show that you had one of these guns, that's not a crime under 18 U.S.C. 922R. Now, prosecutions under 922R also seem to basically be non-existent, as best I can tell. I've done some searches here. I've talked to some people who've done some searches in legal databases, and I don't believe, based on a review of legal databases, there has been a conviction under 922R that one can find, which tells us this is a statute that's not robustly enforced, probably because it'd be very difficult to prove who made the gun, who assembled the gun, the date they did it, and so on and so on and so on. Because there's another issue when you try to prosecute from the government's point of view a 922R case, and that is you have a statute of limitations of 5 years, which means number one is they're going to have to prove that the gun was manufactured or assembled in violation of 922R after, or I should say in the last 5 years, because it was manufactured and made or assembled before 5 years ago, the statute of limitations has run. It's a 5-year statute of limitations. So you're only talking about, the 5 years prior to the date that someone is charged or indicted under 922R, because it's a 5-year statute of limitations. Then it also has to be the process of assembling. It's not the possession. They can't just say you possess it. You have to say, well, who made it? And remember, if any of these firearms were made with these stabilizing braces overseas, for example, I don't even think that's a crime because, again, the manufacture and assembly would have taken place outside of the United States, which the Gun Control Act of 1968 does not apply to acts like that outside of the United States. So if a foreign manufacturer made such a thing, hypothetically, and they shipped it into an American dealer, and the dealer ultimately sold to you, it seems to me that neither the American dealer nor you would be in violation of 922R, because neither the dealer or you actually did the assembly of the gun, of the assembly of the firearm covered by 922R. And in that case, I think the foreign, at least with respect to 922R, I don't think even the foreign manufacturer would be liable under 922R. Maybe there's some other issues he could have a problem with. Of course, there's other laws that apply. I'm only talking about 922R because that came up in the context of the ATF regulations as a reference to it. Now, the reason why this sort of internet turmoil, I think, came about is because the language that the ATF wrote here, and I'll tell you why it doesn't concern me. The ATF wrote in this ATF pistol brace regulation on page 247, quote, the criminal violation under 18 U.S.C. 922R is for the, quote, assembly, close quote, of the semi-automatic rifle. Therefore, modification of this firearm through the removal of the relevant parts would not cure the 922R violation because the assembly has already occurred. So what they're saying here is my point. The crime under 922R is the act of assembling the semi-automatic rifle illegally under 922R with those foreign parts. It's the act of assembly. It's not the act of possession or anything else like that. And that's why what they're saying here is this regulation and the removal of the stabilizing brace. And by the way, they're responding to a particular question raised in the comments to the proposed regulation. They're specifically responding to that saying, look, once you assemble the gun, you've committed the crime. If you disassemble the gun a year later, they're saying, it doesn't matter because you already committed the crime when you assembled the gun illegally under 922R. The fact that you disassemble it later doesn't change things. It's a little bit like thinking about if you've already committed a particular crime, then you apologize for it 6 months later, you still committed the crime. It doesn't matter. That's basically what they're saying here. But it doesn't change the fundamental fact that it's the assembly that's a problem. Now, let us carry on and talk about a couple other examples or hypotheticals that I think kind of get tossed around the internet. Some people have said, well, I made this, I took a pistol, a foreign pistol with multiple parts, as defined by 922R, hypothetically at least, and then let's say hypothetically speaking, you've attached a stabilizing brace to it, and you even put that on YouTube, let's say 4 years ago. Have you violated 922R because you basically have made at least according to the ATF, a short barrel rifle with a stabilizing brace, pistol with a stabilizing brace, making a short barrel rifle years ago, and you put it on YouTube. Is that a crime? I think the answer is no. And I think the reason why is, again, just the practical reality is that even if you show the video, they'd have to figure out the date you did it and where you did it. But set those sort of niceties aside. The reality is this, that up until now, the ATF has taken the position that pistols with these stabilizing braces are lawful guns. They're legal. And I think the proper way to interpret the word willful, meaning a willful violation of the statute, is that you've intentionally violated a law knowing that you're violating the law, right? You know that what you're doing is wrong, but the ATF has told you that these pistols with stabilizing braces were illegal. You could do this. They're not short barrel rifles. So while I think it might be a problem going forward, I think the fact that people have relied upon these ATF statements that this is not a violation of the law and they acted in reliance on it would make it impossible or virtually impossible, if not impossible when I see it, for the Department of Justice to charge someone and indict them on the grounds that they illegally possessed a firearm that violated 922R. So I think federal charges under 922R would be extremely difficult to come by and really probably impossible based on the fact that a mens rea component of 922R is intent or knowledge that you're violating the law, and you would easily be able to say that I was not violating the law because the ATF said these were not short barrel rifles and I could do this, and therefore I did it. So that, coupled with sort of the practical reality, is that, again, when you look for 922R prosecutions, they're simply really not out there. In fact, the only thing that I was able to come across was not a criminal case, but there was one case involving, I think it was an FFL license revocation case. Now, that was a case called Traders Vicks, LTD versus O'Neill, case site 169F Sup 2nd, 957. It was out of the Northern District of Indiana in 2001. This Trader Vic's LTD case from 2001 Indiana kind of is the only reported case I saw in the 922R, and that was not a criminal case. Again, that dealt with an FFL license revocation that was challenged in court. So again, 3 points to summarize. 922R deals with assembling or making of the gun, not mere possession. Number 2 is there's a 5-year statute of limitations by the 5 years prior to the date they charge you or charge someone. And last but not least, of course, if it was actually made overseas, the Gun Control Act doesn't even apply to the act, and it would be merely possessed in the United States by Americans. So again, that doesn't seem to be a crime under 922R. Again, this information I'm giving to you, I think you can share it with, again, the people advising you, your attorneys, see if they agree, because we don't want any of you guys to have a problem with the law. But as I see it, when it comes to a lot of this concern about 922R on the internet, we should always be concerned about what the ATF is doing, because no, I don't think federal law enforcement is always trustworthy, and they're not all honest brokers as I see it. I think there are some people out there in the federal government that if they get a shot to go after gun owners, they will do it. I think that's the harsh reality of it. We've seen this occur in gun cases before in the past, so we always want to be very careful and conservative in how we apply and interpret these rules to make sure that the gun-owning community is protected and doesn't lose any rights or go to jail or anything like that. But I think on the 922 argument, I think generally speaking, for the reasons I've just articulated, American gun owners with these should be okay under the law. And again, run it by your professional experts and see what they think. But in the meantime, if you have not subscribed to the 4 Boxes Diner, please do so. And we'll see you again here at the 4 Boxes Diner.
Orders up. Table 2A.